Okay, so here's the deal. When we look at this, this is basically, we're going to be covering right here, essentially a situation where we've got two cases we can go through. One is a circuit court, but I think what we'll cover on this one is the district court case. Let's do that. Tomorrow we'll do the circuit court change. So there was a claim. It was called Richardson v. Saul, 419 CV 00128-Florida, EDN EDNC, right? We're talking about district court here. So above the SSA, but dealing with disability benefits and the SSA. June 9th, 2020 is when it originally was kind of filed with these details. Now, the court held that there was insufficient logic bridge to an RFC that limits the claimant to up to 9% time off task. So the deal is this. If somebody is like 10% or more off task in jobs, right? Simple jobs, SVP1, SVP2, specific vocational preparation jobs for supplemental security income or Social Security disability insurance. So if they're like 10% or more or above 10%, depends on what vocational expert you get at the hearing, then what happens is you wouldn't be able to keep the job. You get fired. You're not working, if you're working, less than 10%, or perhaps 11%, or sorry, if 11%, you're basically off task. You're not doing the job. You're not following and completing things as you're supposed to. You get fired. It would be a work preclusive situation. Now, I had one vocational expert tell me that 15 to 20% was acceptable. I now have from multiple vocational experts lots of articles related to this. So I'm going to do up a whole video explaining why that vocational expert was 100% incorrect. And so the reason is that there is no job in America that is, like a regular job, not a sheltered work environment where you got your buddies helping you, yada, yada. But there's no job in the national environment, right? A regular real job where you can get your 15-minute break or your hour break, right? You get either one or the other, plus be 20% off task and still keep the job. It doesn't exist. It doesn't exist. So if your impairments keep you from being off task 10% or more, right, then it's work preclusive. You get found disabled, you get a vocational allowance. Now, this is a brief specifically from the federal appeals firm. Let me go through it real quick so you kind of understand where they were coming from this with this situation. They did a nice write-up. It's a cute brief. I like it. The background: Vanessa Richardson challenged the denial of her application for Social Security income by administrative law judge William Anderson. Richardson argued, that the ALJ made errors in determining her residual functional capacity, right? Ability to do stuff, right? Lifting, pushing, pulling, crouching, kneeling, stooping, remembering, focusing, following instructions, blah, blah, blah. RFC, and in evaluating medical opinion evidence, So basically, we're looking at two things here. The claimant is saying the judge screwed up for number one, how they did the RFC analysis, and number two, how they evaluated medical opinion evidence. Both parties sought judgment in their favor, of course. Holding: United States Magistrate Judge, so not an administrative law judge, but like a higher up judge. United States Magistrate Judge Robert T. Numbers Jr. found that the administrative law judge Anderson erred in his determination of Vanessa Richardson's residual functional capacity, and particularly with respect to the time off task limitation. The ALJ had concluded that Richardson would be off task up to 9% of the workday due to pain and medication side effects. Now, I know what you're thinking. How in the helly world would you ever calculate that somebody would consistently at jobs be up to exactly 9% off task? You just couldn't. There's no way to calculate that. You wouldn't be like, well, their depression would be 5% of the day off task, and their degenerative disc disease would be another 4%, and therefore we got 9%. There's no way to calculate it. There's just no way to calculate it. Okay. All right. So the ALJ concluded that Richardson would be off task up to 9% of the workday due to the pain and medication side effects. However, the magistrate judge identified a lack of a logical bridge between the evidence in the administrative record and this specific finding. Putting it simply, how the hell do you conclude that somebody's going to be 9% off task or less? 8%, 7%, 6%, 5%, 4%. Like, what is the logical bridge? How do you do that? Where's the math in that particular situation? Like, how would it, which also calls into validity how bullshitty the entire system is with this 10% off task versus not 10% off task. But the point is, it does bring to fruition how judges can't really look at with vocational experts a medical record, vocational record, and say this person will be de facto this much percent off time, off task at a job. It just doesn't exist. There's no way to calculate it. The critique was that although the ALJ explained why Richardson would be off task due to pain, medication side effects, there was no clear explanation or basis in the administrative record for how the figure of 9% was reached or what evidence supported this calculation. I don't even know. I don't even know how you would do it. I don't. If you guys can think of a way that they'd be able to figure out how much percent off task you'd actually be, let me know. I don't know. Like even if you looked at it from like the VA side, and you're like, okay, well this percentage is so they got a 10% rating on that, and a 30% rating on that, a 50% rating on that. Like even if you went with that, right? Even if you went with that direction, you still couldn't use that to figure out what percent off task somebody would actually be at all different available jobs in the national economy under the Dictionary of Occupational Titles. There's no way. It doesn't exist. All right, so the magistrate judge noted that this lack of explanation made it impossible for a reviewing court to understand the rationale behind the 9% figure, turning it into a basis for remand. So what the higher judge was saying was, hey, administrative law judge, the hell is this? How did you get to 9%? What is the logical bridge? How do I walk to your understanding, right? How do I get to the other side, right? Make it make sense, right? So, okay, so the bottom line here is the magistrate was like, this is not, we have to be able to know how you made up this math. If this is math only you can do, then it's not math we can use on a legal level to, basically destroy somebody's life by preventing them from getting their disability benefits. If you're going to destroy somebody's life so that they can't get disability benefits, we should at least have a logical bridge standard. That's what they're saying here. The magistrate judge underscored the importance of an ALJ's decision to be sufficiently articulated to allow for meaningful judicial review, citing that decisions must include a narrative discussion that cites specific medical facts and non-medical evidence supporting each conclusion. The failure to do so in this case, particularly regarding the time off task limitation, led to the recommendation that the case be remanded to the commissioner for further reconsideration. Here was the insight that they wrote into the brief as they of the review, specifically from the federal appeals firm. All right. The issue comes up occasionally throughout the country when an ALJ attempts to avoid finding a claimant disabled due to time off task. Most VEs will testify that being off task 10% or more of the workday is work preclusive. That's the standard. That's the standard. You get something weird like I had the other day with that whole it was a out west, northwest case. Boy, that was some weird stuff. I'm literally going to be doing a whole video. Shadow, you okay? I'm going to be doing a whole video specifically on that because that was weird. I had a weird case. We're doing a video on it. All right, so some VEs testify that 15% or more is work preclusive. How in the hell could you be 15% off task at a job and still get an hour off for lunch and not be fired? I've never had a job where I could be 5% off task. I have never had a job. Not when I worked at Starbucks. Not when I worked at the library. Not when I worked at the music store. Not when I've had a lot of shit jobs. I've never had a job where I could be overtime. I never had a job where I could be 5% or more off task. Never. Not even when I was a kid and I had to do farm stuff. You're 5% off task, animals perish. Some ALJs try to avoid finding a claimant disabled by assessing a time off task limitation that's only 1% point below the threshold. Not all courts will let an ALJ get away with this unless the ALJ provides a meaningful analysis and explanation. But there's no way. Well, what are you going to say? Well, this medication is 1% and that medication causes 3%. There's no way you can calculate that. There's no potential way. Even if you break it down into the minutes, right? And the claimant's like, yeah, I can only sit for this long. Yeah, I can only, walk this far. I can only stand for this long. I can only, repeat this so many days after a break or so many times within an 8-hour work period, I can only do that twice or 3 times in an 8-hour day, work day, whatever. There's no way to calculate it. It's just fluff and BS. That's the problem. The entire system when it comes to that whole time off task thing is just magical fluff numbers. And literally, we decide whether or not an individual can survive as a result of that. It ain't good, guys. It ain't good. We need to have something with a logical bridge. Anyways, I'll catch you a little bit later. I'm not going to be doing another video tonight because I'm super tired. It is, of course, 1:26 a.m. and I have to work in the morning. I will catch you a little bit later. Please remember to be kind to yourself. Please remember to like. Please remember to subscribe. Go ahead and go to Google if you want to. Type in some beautiful, beautiful stars if you want. Just look up Disability Resolution Law Firm or Disability Resolution Florida. I will catch you a little bit later. Please have a wonderful night, and thank you so much. All right, have fun, everybody. Bye-bye, everybody. Bye-bye.